The subcontractor was the roofer that laid down the roof. We're having water leaks and water damage inside the condominium building. The ISO circular explained that that type of damage caused by the subcontractor's faulty workmanship was covered under the 1986 policy. That exception within the your work exclusion restored coverage that was provided under the CGL insuring agreement. So there's no debate here. That's the intent of the change in 1986 as explained by the drafters. Nothing's hidden here, and the Supreme Court of Florida commented about it, the Supreme Court of New Jersey, and the Cypress Point condominium case commented about it. Another argument that the insurers would make is there can be no coverage under the occurrence in the insuring agreement, the definition of occurrence for a breach of contract. If you breach your contract, it's not an occurrence. It's not accidental. And some of the less reasoned decisions by the courts over the years, maybe some sloppy drafting of the opinions, said, well, breach of contract's not covered. It's just not covered under the policy. But, and again, I hearken back to my J5, J6 exclusions case and our building blocks on exclusions, that exclusions take away coverage. The reason breach of contract is not covered by a commercial general liability policy is because there are breach of contract exclusions. Again, exclusions take away coverage from the insuring agreement, but the broad grant of coverage in the insuring agreement, there's nothing said about breach of contract. If you happen to breach your contract and do negligent or faulty work and it causes property damage, that's covered. That falls within the definition of occurrence and the insuring agreement. It falls within the broad scope of coverage. The takeaway is that the exclusions, breach of contract exclusions, then accept that event from coverage. If you breached your contract, if you didn't put on the right membrane, or you didn't put on enough of the correct roofing membrane, and you breached your contract, it would be a breach of a contract exclusion that would take that event outside the scope of coverage provided by the insuring agreement. And as it says at the bottom, this distinction is sometimes overlooked and has resulted in some regrettably overbroad generalizations about CGL policies in our case law.